joining us on what has become more or less an annual event of a monthly series, I guess. One of the things that we wanted to do at CTIC is to really start a series to talk about current issues and law, not just research, but to follow things that are developing. We decided to do a monthly series. We typically do it around on the first Wednesday of every month, but this year, because of various scheduling things, and because to make sure we got it in front of the Supreme Court term instead of just after the meeting, which is always on Monday, we have you all here today. I don't have to tell you that the Supreme Court has been, shall we say, in the news a bit lately. It's something that's getting a great deal of attention, but not for the reasons that we would like it to, which is what we're going to talk about today, which is substantive cases in the law. But as the drama unfolds one way or the other, regardless of what happens in confirmation hearings, we will have a Supreme Court term that begins next Monday, and we'll have cases to decide. So that'll be a wonderful part of this. We're glad to have you here. Just so you know, this is a monthly series. Just so I don't forget to tell you at the end, we will be doing another one on the first Wednesday in November on the 20th anniversary of the Digital Millennium Copyright Act, which will be hosted by Professor Bogdanesh, but among other people speaking will be Peter Descherny, who is a cinema studies professor here, who, those of you who may not know, is the person who got the first exception to the DMCA passed through the process, and has been sort of become a bit of a model ever since to the people who've been trying to follow in the footsteps. And then the first Wednesday in December, on December 5th, Professor Herb Huddlecamp and the visiting scholar in the Model program, Josh Wright, who those of you who probably know just stepped down as a commissioner of the Federal Trade Commission, will be talking about leading antitrust cases these terms. So looking back at the Amex case, which is the big case we're thinking about for platform markets, that was decided last June, but more to the point, there is the large challenge going on now to the AT&T Time Warner merger that's working its way through the courts. It's been through the district court where the government lost. It's on appeal now. And there's two big cases against Google. The first one came down for $2.4 billion US, and the most recent one at $5 billion US. And let's just say numbers like that have a remarkable ability to focus the mind on certain things. But that's what we're coming up. We hope you'll join us for all those events as well. But we're delighted to have you here today to talk about what should be a very good term. And our first speaker will be Professor Sean Bogdanesh to talk to us about copyright cases.
Great.
Copyright cases.
Thank you, Christopher. Thank you all for coming. My name is Sean Bogdanesh. I'm on the faculty here, and I teach and work primarily on copyright law. And I'm going to be talking to you about the sole copyright case that is on the court's docket for this term. Among copyright scholars, there's a saying, copyright cases that go up to the Supreme Court fall into only one category, cases the court should not take. And they then fall into two subcategories. The first category is a set of cases that the court should not take because it's bound to mess it up. This is an example, a good example of this is last year's case on Varsity Brands versus Star Athletica, where to this day we have no idea what the court really said. The second category of cases which the court should really not take are those copyright cases that are not really super important for copyright law. In many ways, they come across as inside baseball, technocratic, technical copyright cases. And this case, this term, the Fourth Estate Public Benefit Corporation versus WallStreet.com, really falls into this second category because while it reflects a circuit split, it's not really a circuit split of significant national importance, given the way in which copyright litigation works. So what's the real inside baseball technical question being presented? It's interpreting this provision, the sub-provision in the copyright statute, section 411A, which has to do with the requirement of registration before a copyright infringement action can be commenced. Now, while copyright protection is automatic in the United States, meaning that copyright subsists from the moment the work is created and fixed in a tangible medium, the copyright statute nevertheless requires registration for a copyright infringement action to be commenced in a federal civil court. What that means is that you need to go to the, the Copyright Office and file through a set of formalities and deposit a copy of the work and go through what the Copyright Office requires in terms of a submission process, get some kind of a approval of registration from the Copyright Office or an office action denying the registration, and then you normally file the lawsuit. That's what one would think is contained in section 411A. Some courts, however, had recognized that this was a little too bureaucratic and adopted an alternate approach called the application approach, which meant that you didn't have to wait for the Copyright Office to either allow the registration or deny the registration in order to commence the action. So let me walk you through the statutory provision and the two interpretations that made their way through the different circuit courts of appeal, creating the circuit split that the court decides to grant cert on. So section 411A, and mind you, we're dealing with subsection A, not the entire 411, which is a complicated and more extensive provision, says no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. In any case, however, where the deposit, application, and fee required for registration have been delivered to the Copyright Office in proper form and registration has been refused, the applicant is entitled to institute a civil action for infringement if notice thereof with a copy of the complaint is served on the Register of Copyrights. So this provision produces two different interpretations. The first one, called the registration approach, which takes the language of 411A on its face to be true and complete and exhaustive. It says that in order to file the infringement action, you need to have either gotten a registration, an affirmative registration from the Copyright Office, or B, a denial of registration from the Copyright Office. But very importantly, there needs to be an office action. The Copyright Office needs to have made a decision of sorts on your filing. However, the alternate approach, which two circuit courts had adopted, was the application approach, and says the requirement in 411A isn't to be read literally. In certain circumstances, as long as you have complied with all the requirements for obtaining the registration, in other words, you've submitted all the forms, gone through the formal process, and your application is still pending, that is sufficient in order to enable you to file the infringement action. And the application approach obviously sticks to the spirit, seemingly, of the registration requirement, meaning that it's not meant to be an impediment to you obtaining copyright protection. So the overall rationale is, if copyright is really meant to be about automatic protection, the moment you apply, we need to allow you to come into federal court to move forward with your infringement action. So these are the two circuit positions. Now, what's the case for the registration approach, right? The one which is the more dominant approach, and which the United States, in its brief filed in the case, says is the right approach. To understand the rationale for the registration approach, obviously one needs to take the language in 411A a little bit seriously, and to take that seriously, one looks at the legislative history of why we have this particular language in 411A. So if one goes back to what pre-existed 411A, the 1909 Act in Section 12 had a very similar provision. It said in order to commence a civil infringement action, you needed registration and deposit. And this was interpreted by courts as exhausting the gamut of what might exist. In other words, there was a recognition that if there was a denial of registration and the claimant still wanted to commence an action, the way to do it was that you needed to file a writ of mandamus. You needed to go mandamus, and you needed to go and actually implead the Copyright Office through this writ, and with the writ system being what it is, it goes through all the formalities of that writ or the lack thereof. This was seen during the drafting of the 1976 Act as being problematic. So they draft 411A against this backdrop, and they seek to change it. But the component that they seek to change is the need for having to file a writ when there's a denial of the registration, which is why you have the exception in the second sentence of 411A, namely that if there is a refusal of registration, you can still go forward with the infringement action as long as you give notice to the Register of Copyright. So the interpretation taken on the registration approach is that the exception that is indicated in the second sentence is the only exception that Congress intended, right? The canon of statutory interpretation that says expressio unis, namely, if Congress intends to put in one exception specifically, it intends to exclude other possibilities. And that's the approach that the registration approach takes. It also relies on the anti-redundancy or the non-redundancy canon of statutory interpretation by saying that if additional exceptions are recognized, doesn't it make Congress's one exception altogether redundant? Because courts could craft other exceptions in whatever way they wanted based on pragmatic considerations, right? And that's the argument for the registration approach. So what's the argument for the application approach? Well, obviously, it's a much more pragmatic one, which takes the spirit of automatic protection seriously. And it begins with the understanding that office actions sometimes, depending on the workload of the Copyright Office, can take several months. It can take sometimes, as the brief points out for the petitioner, 8 to 9 months to even hear back from the Copyright Office. And what if you want to stop an infringement, not just by accruing damages, but through an injunction before you actually hear back from the Copyright Office? Well, that's the reason supposedly for the application approach. Now, the argument is that even when Congress recognized the need for some kind of action because, or some kind of a plausible intermediate position, because office actions could take a long time, it did so only in a very limited way. So the counter argument to the need to run into court when you're waiting for the Copyright Office is, well, Congress recognizes intermediate positions in the copyright statute in situations where you're waiting for the Copyright Office. One, it allows the tolling of the statute of limitations, so it doesn't allow it to accrue until there's a Copyright Office action. That's the court's interpretation. And secondly, the copyright statute recognizes in Section 408, Clause F, pre-registration procedure. But what do proponents and courts of the application approach say? Well, these exceptions are very, very limited. Pre-registration is limited to a specific category of works. The requirements for pre-registration are fairly onerous. It needs to be an unpublished work. It needs to be undisclosed in particular ways. And the statute of limitations isn't really the sole consideration. It's going out and being able to prevent dissemination, applying for an infringement action under Section 106(3), for example, for violations of the distribution right, even before it gets distributed. So in many ways, the application approach says that what you're doing is loosening up the rigidity of the formal law, reminiscent of the way in which old equity would work. The division between equitable courts and common law courts was, if you recollect, primarily in order to relax the rigidity of common law formalities. And the application approach says, well, allowing you to go into court for pragmatic reasons to get this injunction, which at the end of the day is an equitable remedy, is doing what equity used to do, namely relying on the spirit of the law, but loosening the rigidity of the text. I'll conclude with this other observation, which is that the petitioners, in trying to make the case for the application approach, are trying to rely, and I'm not sure if they'll make this in oral argument, they haven't in their briefs, but they did in the lower court, a 2010 case of the Supreme Court, another one of those inside baseball cases that the court took, interpreting Section 411A. And this is a case of Reed Elsevier versus Munchnick, where the court interprets 411A solely on this question of whether the requirement of registration as a prerequisite for infringement is a jurisdictional or non-jurisdictional component. And the court concludes that even though it's a precondition for an infringement action, it is non-jurisdictional, meaning that its absence doesn't strip the court of jurisdiction to hear the claim, for instance, in a class action claim, where some elements of the claim are altogether unregistered. You can still bring the claim, is the conclusion that Justice Thomas comes to. And the petitioner had sought in the lower court to rely on this, saying, look at the non-jurisdictional interpretation. That ought to be interpreted to indicate that Section 411A is not a rigid bar, and use the less rigid nature of that bar to conclude that it's not exhaustive. Now, the Solicitor General's brief, I think quite rightly says this is somewhat absurd of an argument to make, and it's not clear that it has any real bite, but we don't know if the petitioner is going to make this an oral argument or not. At the end of the day, if I had to predict what's going to come out in this case, I think it's going to boil down to the textualist just saying, what on earth are you talking about? The text is readily clear. The legislative history, so on the one hand, you're going to have people who don't rely on the legislative history saying the text is really clear, thank you very much. Those who rely on the legislative history, I bet, are going to say the legislative history supports the textualists. There isn't really any room for the pragmatic approach, And one way or the other, I think the registration approach is going to be the dominant way that courts come out, regardless of this understanding that there is a broader set of pragmatic considerations at play in the way in which the registration approach actually works. That's my prediction.
Wonderful. Thank you very much, Sean. That's to kick us off on the copyright cases. With that, I'll hand it off to Professor Cynthia Dahl, who will talk to us about the granted patent cases.
Case.
The one. The one.
Yeah. Oh, great, thank you.
Sure.
I'm going to come in front so that you don't get a constant view of the back of my head as I'm looking over my shoulder at my slides.
Should we put a mic on her? Are we recording this?
Thank you.
You can just hold it.
Okay, is that better? Oh, this room is notoriously bad for acoustics. Okay, that's better. Okay, so I'm going to talk to you for a few minutes about Helsinn Healthcare v. Teva Pharmaceuticals. This is the one patent case that we do know is going to be adjudicated this term. There are several other patent cases that Polk will talk to us about in a bit that we may hear from, but this is the one that we're sure going to hear. So backing up a little bit, and let me tell you a little bit about the facts. So Helsinn is a small to medium-sized pharmaceutical company that makes one drug, really. That's where they base most of their revenue on. It's an anti-nausea chemotherapy drug called Aloxi. And because they are a small to medium-sized pharmaceutical company, they entered into two different agreements with this company, MGI, which was an American company out of Minnesota, to fund the drug and to help them with distribution. And importantly, they entered into those agreements more than 1 year before they filed any patent application for Aloxi. Through MGI's public filings with the SEC and through a press release, the license agreement they had entered into together became public. But also importantly to the facts of this case, the specifics of the invention did not become public, just the fact that they had entered into an agreement. And now fast forward a couple of years, and Teva, who makes generic versions of drugs, wants to invalidate Helsinn's patent for violating what we call the on-sale bar. And that is the subject of this case. So in the United States, you probably know that you cannot sell your invention more than 1 year before you file a patent application, or else that patent application is not valid because of this concept called the on-sale bar. Here is the statute that talks about it. It's 35 U.S. Code 102A1. And this statute actually changed a couple of years ago through the America Invents Act. And so I have the pre-AIA at the top and the post-AIA at the bottom. Pre-AIA, it basically said that the on-sale bar is triggered whenever an invention is in public use or, importantly for this case, on sale in this country more than 1 year before you file a patent. Post-AIA, which happened in 2013, says the on-sale bar is triggered when an invention is, and they added an additional clause here, in public use, on sale, or otherwise available to the public. And that change in the law is really what is at base important in this case. So Helsinn sues Teva for patent infringement, and Teva claims that Helsinn's patents are invalid, and they go to the District Court of New Jersey. And the District Court supports Helsinn, says that the patents are not invalid. 3 of the patents were actually pre-AIA. And even though they said that there had been a sale, they said that the reason that the patents were not invalid is because the patentable subject matter wasn't ready for patenting before the date of that sale. So basically, sort of on a technicality, those patents are determined to be not invalid. The more interesting question here has to do with that patent that was filed post-AIA. And they said, even in that case, that this was not a commercial offer for sale, that license agreement between the two companies, because the AIA had changed the standard. And this was a private sale, and therefore it did not invalidate the patent under the on-sale bar. So the question becomes then, when it went to the Federal Circuit, what does on sale mean post-AIA? They added this additional language, and what did that do to change the statute? And it can be interpreted in a couple of different ways. You can look at it to see that that phrase, or otherwise available to the public, modifies on sale. So that means that the sale has to be public. Does it modify the prior phrase on sale such that only sales that make the invention available to the whole public constitute a disclosure? Or does the phrase actually create this whole additional category of potential disclosures? So this would mean that private sales still would constitute disclosure. Helson, of course, interprets the phrase in the first way, saying that private sales don't constitute disclosure, since only the sale was made public, not the invention itself. So on sale or otherwise available to the public equals when the sale makes the invention available to everyone. Teva takes the opposite view, interprets the phrase to mean all sales, if public, trigger the on-sale bar. The Federal Circuit agreed with Teva and reversed the district court and then denied an en banc hearing. So this is what brings it to the Supreme Court. So this is a bit of statutory interpretation, and the question that was presented is basically, does an inventor's sale, excuse me, of an invention to a third party, when the third party is obligated to keep the invention secret, does it qualify as prior art for purposes of determining the patentability of the invention? Have you ruined your chance to patent the invention if you enter into this agreement and then therefore violate the on-sale bar? So what's interesting is actually to look at the legislative history and what Congress actually meant when they tried to change the statute. So originally, the courts had interpreted this language to mean that if you made a private sale, that even confidential sales could trigger the bar. This created a problem because you had secret sales where nobody was actually talking about what the invention was, and so it was invalidating a lot of patents when people didn't even know what the invention was that had been covered. I have a terrible cold that's sucking all the life out of me. Thank you. So this change was supposed to bring the U.S. in line with other countries, similarly to the first to file change. And in other countries, they require invention to be fully disclosed to the public before it constitutes prior art. So what's interesting is that there have been at least 9 amicus briefs that have been filed in this case. Many of them were actually specifically supporting Helson, and that includes the biology sector, the pharmaceutical sector, the Department of Justice, and most interestingly, the sponsor of the legislation, Congressman Lamar Smith. So I don't know if you've ever seen a congressman actually file an amicus brief before, but I thought this was sort of unusual and very interesting, that he came down and basically said the Federal Circuit has this completely wrong. If you go back to the legislative history, we purposely tried to change the law to prevent exactly this situation from happening. The rest of the amicus briefs that were filed were actually neutral as to party, but they basically said they were all intellectual property organizations, like the American Intellectual Property Organization and the IP Law Association of various cities. And they basically all said there's been a grave error in interpreting patent law here, and we take personal offense. And so we are filing an amicus brief to make sure that the Supreme Court knows how we feel and reverses the Federal Circuit. Nobody filed an amicus brief on the side of Teva. I don't know what this says about how the Supreme Court's going to come out. We can discuss that. How they decide on this actually apparently is very important for the pharmaceutical industry. I read a number of papers and a number of op-eds that were talking about this, but when you think about this, small to medium-sized pharmaceutical companies don't have the in-house resources to bring a product to market. They desperately need the help of other companies to help them to develop and to manufacture and distribute their products. And if they can't do that, then it's going to really favor the large pharmaceutical companies and disadvantage the small to medium-sized companies. And so it could have a big, how the Supreme Court comes out could have a big implication for the industry. I guess I have two questions that I don't know the answer to. I'm not sure what the pharmaceutical companies did pre-AIA, if this is so important to them to do these license agreements. And I'm not sure if there's harm in filing the patent first, but maybe the development is not far enough along that, that they can do it, file the patent before they actually enter into these agreements, but that's a question I had. The amici state across the board that it's going to harm all but the largest pharmaceutical companies if the Supreme Court comes down against Helsin. And again, this incorrect interpretation of patent law. The oral arguments are not yet scheduled, but it's an interesting case to watch, and we'll see which way they come down.
Thank you very much, Professor
I
Dahl.
should note in full disclosure, I am on an amicus brief in favor of Teva in that case. So.
Oh,
Ooh.
are you? Which one are you? Which one
The
was
law
that?
professor's brief that Mark Lemley has done.
I didn't see it listed
I
yet.
don't think it's filed yet.
Oh, it's not filed yet?
Yeah.
Okay.
Because it has to come in when the other side files. And if
Yeah.
the briefing isn't done yet, it's not in
So the
yet.
briefing isn't done yet.
Okay.
So the reason there is no briefs on the side of Teva is you file the amicus briefs at the same time the respondent's brief is due. And the respondent's brief is not yet due.
So that's why there are no Teva briefs. There probably will be some.
There's almost always some on both sides these days. The DC Circuit, I'm actually helping file an amicus brief in another there. They actually give you a week after the respondents, which is kind of nice. I don't know why, no particularly good reason, but there's some little things about mechanics of pulling records together and getting the citations right. But anyway, so I'm going to talk about antitrust law. So can you mention the slides? So I have a question. How many of you here have an iPhone? All right. Well, it's amazing. Google, Android has more share, but not apparently in this room. Second, how many of you have ever bought a ticket on Ticketmaster? Okay, so these are your cases, if you will. If I have the presenter. Thank you. So what's interesting about this case is it involves whether you can sue Apple for monopolization of the App Store. And I'm assuming if you have an iPhone, you've bought something on the App Store because that's the only place you can buy stuff, and therein lies the thrust of the case. So what's interesting about this is you have customers who bought apps from Apple's App Store, and they're frustrated by the fact that you can only buy it from them. And I don't know how much you know about this, but Apple takes a 30% cut of every penny you spend. Now, the app manufacturer determines the price, but 30 cents on the dollar of everything goes to Apple itself, and that is one of the requirements of being in the App Store. And second is, you cannot sell through other channels. I mean, they really, really make it very hard, and people think, oh, this is terrible, it's hurting competition, let's sue Apple. They run into this little doctrine called the indirect purchaser doctrine, which ties to a case called Illinois Brick, decided in 1977. And it's a slightly different set of facts, but the notion of the whole notion of Illinois Brick is you can only direct purchasers from Apple can sue. So in essence, they're asking you the question, did you buy your app from Apple, Or, to take Apple's argument, which lost in the Ninth Circuit, is Apple just a shopping mall leasing out space to other stores and you bought directly from the app manufacturer? And the Ninth Circuit said that's not the case, that in fact Apple is the distributor here, they're not simply a pass-through, but they got in this fight over this. Do you get to sue the app developer only, or do you get to sue Apple? Because if you're buying the product from Apple, you can sue them. If you're buying the product from the app developer, you can only sue the app developer, and you can't sue other people in the chain. So why do we have this weird doctrine? So one of the interesting things about U.S. antitrust law, which used to be fairly unique to U.S., is we actually allow suits from private plaintiffs. It's not just government enforcing the violations of the antitrust law, which is people charging too much money and doing things that are monopolies. This is one of those innovations which we've created a lot of doctrines because these have, if you talk to most scholars, private antitrust suits are incredibly problematic. Why? They're most frequently brought by competitors. And when a competitor complains that what you're doing is bad for them, that's usually very good for consumers. That's because you're doing something that's actually, building the better mousetrap is really bad for competitors. You're driving me out of business. Well, in the American way, we believe that that's your message to get better or die. And that the only proper response is to double down. The interesting problem with when you have a whole chain of distribution, I bought a pair of shoes and there was a distributor, there was a shoe store, and there was a shoe manufacturer, and there was a shoe machine manufacturer who sold the machines that made the shoes. They're all involved in the chain of the production. And let's say the accusation is the shoe machine company is overcharging everybody. They're the monopoly. Well, the problem is if you can sue every member of the chain of production, you may have a nightmare of litigation, and you may have multiple suits flying around and suing people all over the place and getting money. And so the Supreme Court said, this is a disaster. Let's only allow whoever's accused of being the monopolist, in this case, the example I gave you, the manufacturer of the equipment to make the shoes, if they're the monopolist, only the person who bought directly from that party can sue, which would be the shoe manufacturer, so the distributor can't sue, the end consumer can't sue. We're going to keep it down to one party. And for the rationales we gave here, why? The real answer is we're going to have a lot of problems about apportioning level damages, because if you have multiple people suing on the whole chain, you can get duplicative recoveries, they all win, in which case you end up paying way too much. Or we have to do an elaborate apportionment regime to say, okay, this level got overcharged this much and this much so that you get the right amount of recovery, but you have to divide it among the levels. And that's what we did before Illinois BRIC, but then the question is, okay, how much of the overcharge got passed through by each level? Because you got, say it's a $100 overcharge, how much of that went to the manufacturer versus the machine manufacturer versus the shoe manufacturer for the distributor all the way up the chain? And we said, we don't want to do this. And so the Supreme Court created this rule. Now, there's a basic problem with this rule, which is in the second part of the slide, which is, well, guess what? If the shoe manufacturer is the only person who can sue the machine manufacturer, but they passed on the whole price increase to their distributor and passed on to the consumers, they have no motivation to sue. They got all their money back. The people who were actually harmed don't have standing. They weren't injured. And so there's been a lot of questions about this rule, about whether it creates really weird incentives. And so a lot of people have been extremely critical of the rule, and many people say it should be repealed. And one of the punchlines about this, as I'll tell you, is they did an exercise called the Antitrust Monopolization Commission, which actually made a reform set of recommendations. They said, get rid of this rule. It's a stupid idea. So because they think it's a stupid idea, we made a fairly Byzantine doctrine out of this. So we've created a lot of funky exceptions to the Illinois BRIC rule because of a lot of times you don't worry about duplicative recoveries. So think about remedies. If you're trying to get an injunction, you don't want money, you just want them to stop. You don't worry about duplicative recoveries. You don't worry about apportioning damages. You just want everyone to stop. Okay. Illinois BRIC permits indirect purchasers to sue for injunctions. Okay. And then the next thing they said, and this is actually, there's a weird thing about this is you get treble damages in these cases. So someone's actually going to get overcompensated. And if the shoe manufacturer who passed on all their harm is the only one that can sue, but they can get treble damages. They actually may have no harm and recover a whopping load of money. So it's kind of a very, very weird situation. Professor Hovenkamp, I'm a little embarrassed to be the person talking about this because he's a much more distinguished antitrust scholar than I am. Because not taking much away from myself, but he's the leading antitrust scholar in the country, if not the world, has the definitive article about cost-plus contracts, which is, if there's a markup where you're just saying, oh, whatever this person is charging is whatever they paid for plus 10%, you're not worried about passing it on, you're not worried about apportioning it, you know exactly what happened. We should have an exception there, and it's been indicated by the Supreme Court as a possible one and drawn on by the lower courts. But the biggest mystery of all is in 1989, just 12 years after Illinois Brick, there was a case that came up called California versus Arc America. Now, many people don't know this, but many states have antitrust statutes in addition to federal antitrust statutes. And state law does not have, California state law does not have an indirect purchaser requirement. Therefore, anyone in the whole chain of distribution or manufacturing can sue. So you think, well, this should be a disaster, we should not let them do this, all those things about duplicative recovery and apportionment, it makes this nightmarish litigation, and even worse, if you're going to have parallel state and federal enforcement, you may lose on both counts and really get screwed over. Supreme Court said, no problem. This is part of federalism. Let 50 flowers bloom, and if states want to do this, they can. Well, this has put the whopping big lie on all the Supreme Court arguments that if you can't apportion and you can't worry about duplicative recovery, we should see this disaster unfolding out of all these state causes of action. We don't. The courts seem to be able to handle apportioning liability just fine. We do this all the time in many, many contexts. So there's this huge move right now to get rid of this doctrine, and many people want this to be the case for that to happen. Now, the funny thing about this is, this really isn't about a chain of production. It's just a question of who are you really buying from? Are you buying it from the app manufacturer or not? And the other little mundane thing about Supreme Court practice, the Supreme Court does not like overruling cases unless the question presented in the cert brief clearly says, should this case be overruled? The question presented in this case did not tee that up. So what you're seeing is a lot of Sturm and Drang about whether this is about Illinois Brick. But really what it's going to be is about, basically, is this a consignment sale where the ticket owner or the app manufacturer is the real owner in interest, why they set the price, and the fact that Apple gets 30% and Ticketmaster gets a cut isn't really the driver, or is it something else? But many people are going to want to turn this into a major pivot in antitrust law. I suspect that they're not going to get their way, just because there's too many ways for the courts to chicken out on this. But the reality is this is a big doctrine. This gets a huge amount of press, and it's going to create a lot of fodder for law professors to write more articles, because it's going to stir the pot one more time, but probably in the end of the day not do very much. I now hand off to Professor Wagner, who's going to talk about some cases that are pending, that have cert petitions filed. They're pending in the docket, but have not been, the court has not decided whether or not it's going to take them.
All right, thanks everybody. Let me have that clicker. All right, so what I'm going to talk about now is we only actually have, for IP and antitrust cases, just those 3 cases that we've already discussed that are already on the docket of the Supreme Court for October term 2018. However, they're only somewhere between a third and a half done with the number of cases that they're going to take, right? We don't know exactly how many more they're going to take, but tradition would tell us that they're somewhere around half done at this point. So there could be several others, and there are some interesting cases still pending. So the first thing we want to do, though, is we did this last year, so we have to give ourselves scores, right? So, these were the cases on the October term 2017 docket that we did last year, the Oil States case and the Mittal case, right? So Oil States versus Greens Energy was a case about whether or not the post-grant review or the IPR review system is constitutional, right? And what I said is I predicted that we're going to affirm the Federal Circuit. The Federal Circuit held that the IPR system was indeed constitutional, and because I thought they just wouldn't tear down this multi-billion-dollar industry that had been created, and then probably on the language in this statute. And 7-2, they did just that, right? Justice Thomas, writing the opinion, said the IPR procedure fits well within what's called the public rights doctrine, and that really it's not any different than the decision to grant or deny a patent in the first place. The argument there was that, the argument that was being made to the court was that when this IPR process, this post-grant review process, invalidated a patent, that was an impermissible use of what should be Article 3 power, right? Because only Article 3 judges should have the right to take away somebody's property rights, right? So the public rights doctrine basically says, no, this is just a regulatory scheme, and part of the regulatory scheme is that we can give you a right and we can take it back later, right? And that's basically what Justice Thomas said. Two things are interesting about oil states, right? One is Justice Gorsuch, right, says, well, I'm not buying any of this, and tradition and history require that Article 3 power is required to withdraw patent rights once granted. This is going to foreshadow a number of cases that Gorsuch was involved in, where he believes that Article 3 judges should have a lot more power than they do now. The other thing that was interesting is Justice Thomas, in the majority opinion, makes very clear right at the end of the opinion, we are not taking a position on whether or not patent rights are private property rights and thus subject to takings analysis, right? They say, we have not decided that in this case. Why would they say that they didn't decide that in that case? It wasn't even an issue in this case, right? So clearly they were suggesting maybe we might want to decide that in this case. And we'll see in just a few minutes that is indeed something they're going to be asked to decide this term. Whether they actually will decide to decide it, I don't know, but they're going to be asked to do that, right? So the other one was the Mittal case, right? And the Mittal case was about the following question. If I apply, this is also post-grant review, if I petition the Patent Office to review 7 claims in a patent, and the Patent Office decides that 3 of those are worth reviewing, and they issue decisions on 3 out of the 7, is that okay, right? This is a statutory construction argument because the statute says that the Patent Office shall issue a decision on all of the claims appealed, right? And so straightforward in that sense, statutory interpretation, right? However, what it's really about is what's called Chevron deference, right? Chevron, for those of you who don't know, is this doctrine that basically says that when it's a reasonable interpretation of an otherwise ambiguous statute, the administrative agency is given deference to that interpretation as long as it falls within a range. And so it's really about whether the PTO had a reasonable interpretation of this statute, right? This was reversed. Gorsuch wrote and said, look, the word shall is really clear here, right? So Chevron doesn't even apply. You have to, you shall issue a decision on all of the claims that are offered. And it undermines fairly significantly the Chevron decision, right? So this ends up being a 5-4 case, primarily because it's a tussle over how much power Chevron is going to have going forward. And that, of course, applies to all of administrative law, not just patent law. Breyer writes a dissent and says, look, we do this every day. We've done this for 4 decades. Chevron applies because it's an otherwise ambiguous statute. There were various provisions of the statute that you could read to make it ambiguous, and the PTO's interpretation is reasonable, in part because very often if I apply to have 7 claims reviewed, right, then only 3 of them merit anything. Under the interpretation now, post-Mittal, the PTO has to deny all of those, all of the petition, and hope that you then refile your petitions until they get down to the 3 that they want to offer, they want to decide on. So it's sort of a form over substance argument.
So were you right about that one?
Well, I punted on that.
Oh, that's cheating.
I said I didn't know because it was a Chevron issue. All right, so let's talk about some things that we should be watching for October term 2018. First case, Regeneron Pharmaceuticals. The patentee, this is about inequitable conduct. The patentee withheld 4 references from the PTO. Inequitable conduct requires materiality and intent. Everybody agrees that there was, well, they're still disputing it, but there was materiality, meaning these were important references that were withheld. However, the weird thing that happened here was that intent was inferred by the district court, in part because the party, the patentee, was extremely abusive during the litigation itself. And so what the district court says, well, I infer from the awful behavior of your attorneys before me that your attorneys probably behaved badly before the PTO, right? And therefore, I am inferring intent to deceive the PTO because of the bad behavior and the deceptive behavior, which everyone sort of agrees was pretty bad behavior before the district court, right? And so the real question is, so the Federal Circuit affirmed that and said you can infer intent under the doctrines that the Federal Circuit follows from basically anything. And the court said this is at least reasonable to infer the intent to deceive the PTO during prosecution because of the bad behavior later. And the petition is whether you can extinguish a patentee's right by litigation misconduct as opposed to purely the conduct before the PTO, right? We will figure out whether this is having been taken, we will know tomorrow because they're going to have the first batch of orders that'll come up this week, tomorrow by noon. So we will know. My prediction is they will take this because this does seem like a pretty outlandish result.
And the outcome of the case?
Oh, they'll take it and they'll say that it has to be only intent that can be inferred from prosecution, right?
So reverse.
Yeah. Amgen versus Sanofi. Patent was held to violate the written description requirement and the enablement requirement of Section 112. The issue below was relevance of post-priority date evidence. However, the petitioner tees up what I certainly hope is the issue they take, which is there in fact a written description requirement at all? Those of you who've taken me for any IP classes know that this entire thing of a written description requirement is made up, right? The Federal Circuit just made this up. There's very little statutory basis. In my view, they call it possession. They can't figure out what it means. Please, Supreme Court, if you're listening to me, take this case, right? I usually say there's nothing the Supreme Court can do that makes the patent law any better. Here, I think there's no way it can be worse, so they should hopefully take this case. This has not yet been scheduled for consideration, so we won't know for at least a few weeks, but I'm hopeful that they will take this case.
And you'd like them to reverse?
Oh, yes. Please reverse, right? Get rid of the separate written description requirement. Go back to the old enablement.
I got to get you on the record so when we take score next year.
We'll do. We'll score. These slides will be kept. Return mail versus U.S. Postal Service. So this is interesting. So Return Mail owns a business method patent. They sue the Postal Service for patent infringement. Now, you cannot, however, sue the U.S. government for patent infringement, right? The U.S. government has sovereign immunity. However, you can sue the federal government for damages, right? You can sue the federal government in the Federal Court of Claims and say, you give me money for something that sort of looks like patent infringement, but it's not technically the same statutory scheme as patent infringement, right? And so the Federal Circuit says, what you do in normal litigation very often now, and the modern litigation technique is if somebody sues me for patent infringement, I immediately take their patent on a petition for it to be post-grant review, which has two benefits. One, I might, in a very inexpensive proceeding, get to get rid of that patent, right? Two, it at least ties everything up for years, right? So it slows everything down. And so the Postal Service, behaving like any good litigant would, immediately throws into a post-grant review to try and slow everything down and maybe get rid of Return Mail's patent, right? The Federal Circuit said the Postal Service had, in fact, standing to bring this because they were being, quote, sued, just like anyone in normal district court would be sued, right? So the petition, Return Mail, Return Mail got all their claims canceled, they lost. And so now they're suing, or they're appealing to the Supreme Court and saying the U.S. Postal Service is not being sued for infringement because this is a statutory compensation scheme, not an infringement action, and therefore under the statute, it lacks standing to bring post-grant review, right? So we'll see. Not scheduled yet. I don't think this is I think it's probably the right answer. I think that this is a a method for, that there's no particular reason that the Postal Service shouldn't have the standing to bring an AIA post-grant review just like anyone else. So I doubt they're going to take it, but who knows. There's two cases on the docket. Well, one's on the docket, one hasn't yet been scheduled, that are the fallout from the oil states case that I talked a minute ago, right? In advanced audio devices, they're making the straightforward case that if you cancel my patent under a post-grant review proceeding, that is exactly the same as the federal government taking my private property and you need to give me money, right? And it's particularly retroactive to pre-2011 patents, which were granted before this new post-grant review system came into play. It's not yet scheduled. I doubt they're going to want to take that case. I don't think they want to go down the road of deciding that patents are compensable takings. And of course, the court's takings jurisprudence is confusing, and they haven't taken many of those, but I doubt it. Smart Flash versus Samsung might capture their interest a little bit more, which is they're not making the argument that it's a compensable taking, but what they are doing is they're picking up on some of Justice Gorsuch's arguments in the dissent in oil states and saying the structure and the composition of the Patent Trial and Appeal Board, the body that actually determines whether these post-grant reviews go forward or not, is unconstitutional. Among other things, they claim that all of the judges on the Patent Trial and Appeal Board need to be confirmed by the Senate. They need to sort of look like Article III judges, that there needs to be a more robust appeal process and so forth. So they're arguing very similar to the compensable taking argument, but they're doing it a slightly different way. They're arguing about the structure and composition of the Patent Trial and Appeal Board, saying that that's an unconstitutional setup. This is one we'll learn about tomorrow. My prediction is they will not take that one. I don't think they want to go back to the well of oil states and Mittal 2 years in a row. Justice Gorsuch seems really excited to dig in and sort of disrupt settled expectations in these areas, but I'm not sure that he's going to get many takers to go back that soon. RPX versus Chan Bond is an interesting case. RPX, for those of you who don't know, in the patent world, is basically a reverse patent troll, right? What they do is they buy up patents, they make deals, and you can contract with them for sort of an insurance policy. So they agree not to sue you on any of the patents they have, and they agree to fight other people who might sue you if over their patents, right? So RPX is an interesting player in the patent world. That top line is left over from an earlier slide, not here. IPX is filed in a inter partes review against Shanbon's patent, and most of the claims are upheld. Now, the statute says that if you don't like the decision of the Patent Trial and Appeal Board on an inter partes review, you can appeal. You appeal to the Federal Circuit and ask for them to review it, and if reverse is warranted, they can do that. So RPX did so. However, the Federal Circuit dismissed the appeal out of hand, saying there is no standing under Article III to bring an appeal into the Federal Circuit, which is an Article III court, right? Because RPX has no danger, right? They're not in any danger of being sued. They're not practicing the patent. They're just sort of a disinterested third party who happens to be filing inter partes review, right? So the Federal Circuit says you're out, you don't have Article III standing. And so the question is, and RPX is arguing at the Supreme Court in this petition, whether or not you can create Article III jurisdiction by statute here, and if so, then they're allowed to do so. This apparently is a pretty open question in the federal court's jurisprudence. Can statutory provisions create an Article III standing, even when there's no case or controversy? There is no case or controversy because RPX, they're not in any danger. They're never going to get sued under this patent. So that's an interesting case we will learn tomorrow. Not so much a patent case, although it has bearing on patents. It's a pretty interesting federal courts case. And that, I don't think that's, I had I guess the latest ones didn't get in. So two other cases. One, and I'll try and remember these off the top of my head. One was a copyright case, and this is the Oracle, the latest iteration of Oracle versus Google, right? It's been going on for years and years and years. The question in this case is basically the scope of fair use. What can be called fair use, and in particular whether application program interfaces, so the hooks between different kinds of computer programs, are those A, copyrightable? Answer is yes, as it turns out, and B, are they subject to fair use if, as what happened in this case, a company like Google basically takes the ones from Java, which is owned by Oracle, and uses them in their Android operating system, right? So Google, when they're writing Android, took a bunch of code from Java, application programming interface, API code. One, it was easier to do. Two, it was quicker. And three, they really needed interoperability, so that was something that they wanted, right? This has been up and down several times to the Federal Circuit, back and forth. The latest iteration was a jury found fair use of after a multi-week trial, found fair use and allowed Google then to escape infringement because they said what Google was doing by using the code for the APIs was fair use. Interestingly enough, it went to the Federal Circuit in the spring, and the Federal Circuit decided as a matter of law that it could not possibly have been fair use, reversed it and sent it back to the district court, right? So I think where the case is right now is it is waiting. The time limit has not yet run out for a cert petition. I think everybody expects a cert petition to come because why not? It's been going on for 12 years. You might as well go on for 14, right? And it's a pretty important issue to determine what the scope of fair use, particularly in the software context, is. Sham, I don't know if you have anything to add to that, but I think we all expect at least a petition to happen. Whether the Supreme Court gets involved, I don't think we know.
Right, and I think, so Google has said that it's going to file a cert petition.
Right.
Before it goes back. So that after the most recent iteration, the Federal Circuit sent it back for a third trial now.
On damages only. Right.
Google has said that they're going to file a cert petition. What makes this cert worthy, and so the Supreme Court stayed out of Oracle versus Google in the first two iterations because of the complexity of the matter, and perhaps we're all better off for that, given how they mess up copyright doctrine and don't want to get there. But there's a complexity here because, remember, the Federal Circuit had jurisdiction over a copyright case through its supplementary jurisdiction because originally it was a patent claim with copyright infringement claims. And what the Federal Circuit did on both occasions was sit as the Ninth Circuit and apply regional circuit law to the case. And in so doing, there's a credible case to be made that it misapplied Ninth Circuit law. Now, the problem is when the Federal Circuit decides something in the patent context, a panel, it's corrected through a Federal Circuit en banc. But the Federal Circuit cannot sit en banc replicating and mimicking the Ninth Circuit here. So the only avenue for this to be corrected, and this is an argument that my friend Peter Manel has made very persuasively in a piece published in the Berkeley Technology Law Journal, the only way they can correct this is by taking cert. Because the Ninth Circuit isn't going to sit en banc for a panel decision that was trying to replicate a Ninth Circuit panel, and the Federal Circuit isn't going to sit en banc for a panel that was pretending to be the Ninth Circuit. So that's the argument for the Supreme Court to take it, even though the complexity dictates otherwise.
Good. And so that petition is not, although Oracle says, or Google, no, Oracle says they're going to file, right?
Google.
Says they're going to file. So we expect it. So there's a trademark case that is cert pending on this trademark, right? So somebody goes and gets a trademark for fucked, right? The argument, there is a statutory provision that says you can't get immoral, scandalous, or disparaging marks, right? So in last year, the Supreme Court took the last part of that, the disparaging mark issue, and in a case called Tam, ruled that that was unconstitutional abridgment of free speech, right? So that was an unenforceable restriction, that in fact, you can in fact register marks that are disparaging of particular people. However, they didn't say anything about the other parts of the statute, which say that you can't register immoral or scandalous marks, right? So the federal or the patent office, the trademark office rejects the registration for fucked, right? Saying this is a homonym for an immoral and scandalous word, and so therefore we're going to reject it, right? And the trademark owner, or the person who wants to be the trademark owner, appeals and says to the Federal Circuit, look, you know, last term they already decided this issue. They said it was a First Amendment violation. Federal Circuit agrees. Says, no, you can't have immoral or scandalous rejections anymore for the same reasons that the court said in TAM. Those are straightforward First Amendment violations. So the big thing, the thing that everybody in the trademark bar was waiting for this summer was whether the patent office or the trademark office was going to actually try to get this, the Federal Circuit's decision, which said that they could not reject this for immoral or scandalous reasons, whether they were really going to try and take this to the Supreme Court again. And indeed, on the very last day, at the last hour, they filed a cert petition saying that although last term TAM says that you can't, that it's a First Amendment violation to have disparaging marks eliminated, the immoral and scandalous is a different thing entirely. Totally different, right? This is just a reasonable regulation and a restriction on registration of marks and doesn't suppress speech in any way. I'm dubious whether that's going to survive the TAM case, but clearly the Solicitor General's office and the PTO are joining forces to try to get that Federal Circuit opinion overturned and make sure that Fox never becomes a trademark. So, all right, with that, I think we are done. Happy to take questions about any of these cases, talk about anything else. We have a reception for everybody downstairs in the Great Hall. Remember, if you need CLE, to make sure you signed up outside and gotten the form. And if there are questions, we'll hear them now. So. And they could be questions on either these or any of the cases that are already at the court.
Please.
You mean on copyrightability? Well, that was... Oh, not really, because Google straightforwardly admits they just copied the code entirely, and they did primarily for interoperability and convenience reasons. So it's not so much a software reuse thing as much as it is they just flat copied the software.
But in terms of interoperability, I think that's what Section 117 is intended to address.
Yeah.
So there was no discussion. There was no discussion of 117A, and so in round two, which was about copyrightability of APAs, the entire focus was on Section 102B. The entirety of going back into the legislative history, no discussion of 117A, because copyrightability, the focus was entirely on non-literal elements and the extent to which SSOs would qualify as copyrightable subject matter. On the second round, the remand was exclusively on fair use. And so the discussion was around the
Copyrightability dropped out.
Exactly.
After the second round.
So this round, it's entirely unfair use, and what I think, to the extent that there's any part of the substantive doctrine that makes it certible, it's the component where the court says we're going to examine it de novo, with the exception of historical facts. We're going to basically take a different standard and overrule the jury.
I have a question. I'll take panelist prerogative, ask a question. So why do you think they teased us in oil states and dropped those footnotes about we are not ruling on this and not ruling on that, and then won't take these cases that allow them to do that? Why do you think?
So my sense is they may want to, at some point, get into the question of whether or not a patent is private property for purposes of takings and other jurisprudence. I think I have a couple reasons that I doubt they're going to do it now. One, it's not clear to me these cases tee that specific issue up very well, right? The one party that's actually making that argument has a really bad case generally, so it doesn't strike me as an interesting, very interesting case for them. The other thing is, do they really want to go back into that realm of whether or not it, sort of into this whole realm of whether or not the IPR system is going to be constitutional, because it calls all of that into question, right, if they go back there two terms in a row, right? That's the other reason. They just sort of like to let things lie for a little bit. I guess, my prediction is they'll let it fester for a little while and eventually sort of get back to it. They've teased us several times before about patents being property rights. So this is not the first time we've seen that tease, and I think they may well eventually get there, but they haven't actually got it yet. So.
But this isn't really about patent law. It's about the scope of the administrative state. And Gorsuch doesn't like Chevron because it gives a lot of room for the administrative state. And the problem with...
And he doesn't like all these statutory schemes that allow for standing and Article I courts and all of these things, right?
And the problem he's got here is by acknowledging that it's a public right, it's not explicitly tied to whether it's a property right, but public rights are things that the government can just change at will. So it's like, I always think of zoning. Your house is zoned a single, multi-dwelling, they change your mind, it's only single, family occupancy. You say, oh, my property's worth a lot less. Well, too bad. I mean, that's just comes with the turf,
Yes and no, though. I'm going to disagree.
But this is the question that's lurking behind it, is there's one version of private rights that allows the government to redefine it at will. If it's a property right, is there a hard core to it that cannot be redefined at will? And so you have a coalescence here between the nature of the right determining what venue it can be decided in, an agency versus a court, and is there a substantive implication of what the government, a limitation on the government's ability to reconfigure that right that's inherent, that's tied to the choice of whether you can do it, the venue for deciding it? The pretty good assumption is that if it's a public right and can be redefined for purpose, that's one of the reasons you can allow it to be an administrative agency instead of a federal court, is that it can be redefined by the government. There is an overhanging implication that copyright and patent can be redefined at will by the government. And that's the thing that they're trying to decouple by having the two.
I think I agree with most of what you're saying, except that there's an additional layer of complexity that I think the court would have to get into if they're talking about takings and patent law, which is the applicability of regulatory takings jurisprudence to this particular context, right? So, and you have statutory language that seems to forbid the entrance of regulatory takings jurisprudence. I mean, the patent law, Title 35 clearly says the patent grants you the right to exclude, which seems to make you believe that if you're going down the takings jurisprudence route, you'd have to rely on this set of cases that says that property is the right to exclude, cases like Loretto versus Teleprompter, as opposed to case law that says if a zoning regulation, and this is property case law, if a zoning regulation deprives you of the essential economic benefit of your property right, even though it isn't literally a taking of your property right, if it deprives you of your essential economic benefit, it's still a taking subject to the Fifth Amendment. And I think the big question that is unresolved, even within the scholarly context, is whether regulatory takings jurisprudence applies to the way in which you slice and dice patent and copyrights. I think the actual invalidation, people are pretty much in agreement that it would amount to some kind of taking, especially after the conclusion that trade secrets are property in cases like Ruckelshaus versus Monsanto. But it's the regulatory taking stuff that gets into the weeds on administrative agencies and their power to redefine, slice and dice the rights.
But most of us think that's much ado about nothing, because regulatory takings cases always lose. I mean, just the doctrine is set up so that even if it applies, what you have to prove, it has to deprive you of all value.
Right.
And,
they lose except if you're dealing with beachfront property.
Yeah, pretty much. I mean, there's some very strange cases about that, but most of us think that it's a dead doctrine, essentially. It's not a very vital doctrine, doesn't lead to very much. And you see this, the government regulates us all the time and changes the value of our property all the time. We don't get compensated. It's just, that's the reality. Well, at this point, I believe all that's standing between us and drinks is further questions. So on that note, I think that we'll adjourn this. Thank you for coming.
All right, so we will do, as we always do, in the late spring, we'll do a roundup that will go over whatever cases have been decided by then, which will probably only be the 3 that we've talked about now, since the ones they add later usually don't get argued and decided till later.
Summer, yeah.
But we will do a wrap-up in the late spring, so look for that.
And we hope to see you the first Wednesday in November to talk about the DMCA and copyright law. Professor Bangladesh and Professor Desherney and Corinne Militello.